Good afternoon, everyone. Thank you for being here once again. It just occurred to me as I was looking at that intro slide that we will need a new slide in a few weeks when we turn the page to business in 2024. With that in mind, a couple of announcements here just in terms of scheduling. Next week will be our usual webinar on the 12th. On the 19th, I will be back and we will do a special edition, which is going to be a look back at 2023, some of the biggest stories of 2023, the biggest takeaways from the year. Then we're going to take a little bit of a vacation and we will be off on December 26th and January 2nd for a little break. And then we'll be back for business in 2024, the week after that, which I believe is the 9th, January 9th. So a little look ahead of what's coming. But we still enjoy putting this on. You're still coming and listening, so we're going to keep going into the new year. So I'd like to, with that, introduce this week's lineup and a very labor-heavy set of topics, as often happens when I'm hosting. Given the season, we'll have Nick talk about the hazards of holiday parties in the workplace. Lots of legal issues in that realm. I think he'll have a little bit of fun with that. Krista here to update us, Krista Cook from our Syracuse office to update us on some pay equity issues and the OFCCP. And then an important update from Janelle Dewey here in our Syracuse office about a new extended statute of limitations. And then finally, Suba, one of our regular contributors who I always appreciate coming here talking about New York State minimum wage and exempt salary levels, something that a number of you have asked about in your follow-up surveys and in the Q&A, and important information for you to know before the new year. So with that, I will send it over to Nick Jacobson, an associate in our Rochester office and Syracuse office. He spends time in both and talk about holiday parties. Thanks, Nick.
Thanks, Kristen. Next slide, please, Kathy. All right, so today we're here to talk about some holiday party hazards, and I'm very glad to see that my GIFs are working. Hopefully, they'll be entertaining throughout the presentation. Next slide, please. All right, so for a first holiday party hazard, we have alcohol. Next slide, please. All right. So alcohol is not something that we normally have in the workplace, but of course, at a holiday party in the holiday season, it's common to allow employees to let loose a little bit and enjoy a cocktail at the office or at the holiday party. But there's certain risk factors that enjoying some beverages in the workplace can increase. And the first of those is the potential for inappropriate behavior. I've had a few cases during my career that have involved allegations of inappropriate conduct at a holiday party. It's certainly important to keep in mind that even though employees might be allowed to have a drink at a holiday party, personal conduct policies remain in effect. And that includes if the holiday party is occurring outside of the office environment. Harassment or inappropriate conduct at a party outside the workplace can still affect the workplace and the people in it. So certainly we want to avoid anything like Michael Scott's Serenade of Your Body is a Wonderland at the holiday party in the office, which was a treasure trove of references for this presentation. Another risk that intoxicated individuals at a holiday party presents is the increased risk of injury. Employers are potentially liable for injuries occurring at a holiday party, including injuries caused by intoxicated guests or employees. That's because under the law, there are certain circumstances when the law imposes a duty on property owners to exert control over people they've invited onto the property, and where the property owner fails to exert that control and an invitee causes an injury to somebody else, the property owner, in this case an employer, can be held relevant in certain circumstances. Another risk to definitely keep in mind during the holiday season is the risk posed by drinking and driving. Under the law, bars and restaurants can be held liable under what's known as dram shop liability. Now, that type of liability would not apply to an employer hosting a holiday party and serving alcohol for free because there's no commercial benefit to the employer. Uh, and even though employers and property owners can be required to exert some level of control over invitees, courts have held that that duty does not extend to invitees leaving the property. So at the end of the day, an employer is unlikely to be held liable if a guest or an employee at a holiday party drinks and drives. That being said, there's still a whole number of reasons why we want to avoid employees and guests drinking and driving from parties whenever possible. The first being, of course, that we don't want anyone to get hurt. And of course, the news story, even if the employer isn't going to be liable at the end of the day, a news story of an employee or a guest leaving a holiday party and causing an accident, certainly poses a hazard of some negative publicity, certainly. Next slide, please. All right, so our next holiday party hazard, guests. At holiday parties and at holiday time, there's going to be different people in the office than we would normally expect. The first, family and friends in the workplace might be invited to a holiday party. We also have vendors that we might be bringing into the workplace. It could be a Santa for children, catering, bartenders, you name it. There's the potential for vendors that we might not normally have in the workplace to be there for a holiday party. And last but not least, the potential to have kids in the workplace at a holiday party or other function at this time of year. And, for all of these groups, they all would pose different potential risks and concerns. Next slide, please. One thing to keep in mind is safety and security. Certainly you want to be able to relax, enjoy the party, but we don't want to forget about protecting sensitive information. We don't know if Joe Pesci or someone from the Wet Bandits is going to be there scoping around for sensitive information, potentially employees of vendors, other guests that we, don't normally have in the workplace. We want to make sure they're not getting access to sensitive or confidential information of the company, of clients, or of employees. You also want to take care to secure any dangerous areas or equipment to prevent any guests or vendors from being injured in the workplace if the party is occurring at the office or the work location. Another thing to think about is ensuring sufficient supervision and control. And you definitely want to consider who is going to be attending the party. And if there are going to be children, you may want to think about an increased level of supervision, somebody keeping an eye on the party to make sure everything stays safe. Another important reminder is an employer has a responsibility to address inappropriate conduct by guests and vendors who may not be employees. The employer has a duty to prevent harassment in the workplace and to take action if harassment occurs, regardless of who is the perpetrator of that harassment. Next slide, please. And then our final set of holiday hazards, the environment. Home Alone was again a great source for this one. Poor Merv having a rough time there. Next slide, please. So employers are responsible for providing a safe environment for guests. Things to think about, slip and falls, especially at this time of the year when there's the potential for ice on the premises. If an employer has noticed that there's an icy condition on the premises, for example, if employees have slipped and fallen in a particular area and a guest to a holiday party comes and slips and falls in the same area, there's the potential that the employer could be held liable for that injury. Same with other unsafe conditions on the property or potential injuries for dangerous holiday activities that you might be doing at a holiday party. If employees are injured, they may be entitled to workers' compensation, even if they're injured due to their own negligence. Remember, negligence is not negligence on the part of an employee is not a bar to workers' compensation. Conversely, if a guest attending a holiday party is injured due to the negligence of an employer, their recovery would not be limited to workers' compensation, and the employer could be liable for things like the pain and suffering of the guest. So we definitely want to be concerned about and thinking about general liability issues and potential hazards in the workplace. Certainly one potential way to minimize those risks would be having the party at an off-site location where a vendor is responsible for providing the safe and secure environment and for overseeing the party. Next slide, please. And just a couple of other things that you might want to keep in mind as an employer during the holiday season. The holidays can be an extremely stressful time with the potential for increased financial and family stress. So this might be a good time to remind employees of available EAP services. Another thing to remember is at this time of year, it's particularly important to maintain an environment that is respectful and tolerant of all beliefs and customs. You need to be prepared to address potential religious accommodation requests, including time off for religious observances. But just a reminder, there is a different standard for considering religious accommodations than there is for considering disability accommodations. And it's actually a much lower standard. So if you're dealing with any of those requests for religious accommodation, time off for religious observances or something else, if you have any questions, please don't hesitate to reach out to us. And that's it for me. Thank you.
Thanks, Nick. Your gifts put a smile on my face, so thank you for keeping it fun for us.
No problem. Thank you.
You're welcome. But you're right. I mean, the holiday party scenario does present a long list of issues, so that was interesting. So moving ahead, Kathy, if you could advance the slide to our next presenter. Krista, thank you for being here to talk about pay equity. Go right ahead.
Thank you, Kristen. Hello, everyone. Thank you for joining us today. I am here to spend a few minutes kind of giving a heads up to all of our federal contractors out there on some developments we're seeing at the OFCCP. And while my comments are focused on the OFCCP, I think that those of you who are not federal contractors can benefit from some of these comments, because I'm going to focus on this issue of pay equity. And pay equity, pay transparency, and claims of compensation discrimination have been a rapidly developing area, gaining a lot of attention for our clients and employers in general. Employers are facing pay equity claims, whether in court or before the EEOC or pursuant to a compliance audit by the OFCCP. And in those, as a result of those, whether you're in court, you're at the EEOC, or you're in front of the OFCCP, a lot of employers are facing large settlement demands and large settlement payouts. So pay equity, what exactly is that? The concept really is that people in the same workplace should receive the same compensation for doing the same work. We know that the applicable laws include, there's various laws, both federal and state. Kathy, could you just go to the next slide, please? And those include, right, we know the Federal Equal Pay Act, Title VII, New York Equal Pay Act. But for federal contractors, the applicable law is the Executive Order 11246. And that order prohibits federal contractors from discriminating on the basis of various protected categories, including gender. To be clear, Executive Order 11246 does not have any pay equity mandate specifically, but it is a non-discrimination law. And the trend that we have seen is that over the past couple of years, in particular, OFCCP has relied on this order to aggressively pursue pay discrimination cases. You can move to the next slide, Kathy. So what we have seen over 2023 and more recently is that the OFCCP has hired a significant amount of staff. They've added to their staff with the intention of using those individuals to focus on audits, including pay equity audits. They have also announced, and we have seen on their website, significant penalties for alleged gender discrimination in pay. We see with this increase in staff, we anticipate that in 2024 that we will probably see an increase in compliance audits. In 2023, OFCCP announced and conducted over 1,500 of those audits for federal contractors. And what we've seen from the scope of those audits, and I've been involved in representing some of our clients in these OFCCP audits this year, is that the scope of the audit is almost unlimited. The amount of data that they're asking for and the focus is undeniably increased. One of the trends that we want to alert you to is that in these audits that oftentimes focus on compensation issues, is that the audit typically is involving compensation interviews. And that was always a possibility and occurred to some extent historically. However, we've seen a significant increase in that, the compensation interviews, not just of the compensation manager, but also of other individuals within your organization. So including your supervisors, your managers, and in the event of an audit, and those individuals are asked to participate in compensation interviews before the OFCCP, you're going to want them to be versed in not only affirmative action obligations of your organization as a federal contractor, but also you will want them to be versed and prepared to discuss your organization's compensation structure, the factors that impact compensation, their participation in compensation decisions, with the ability to explain how and why compensation decisions are made. And certainly, those individuals should be able to speak about your organization's efforts and education within your organization about your affirmative action obligations. So we're seeing a significant trend and uptick of financial penalties, unfortunately, as a result of these increased audits. In 2023, OFCCP's compensation settlements amounted to over $5 million. Again, just focused on compensation discrimination settlements. Of course, there's other areas that the OFCC focuses on, for example, discrimination in hiring, the provision of reasonable accommodations to individuals with disabilities. But what we are seeing is that the amount of settlements and penalties focused on compensation discrimination has certainly taken an uptick. And I know, in our slide here that Pfizer recently agreed to pay $2 million under a conciliation agreement that it entered into with the OFCCP. Now, this conciliation agreement with Pfizer is part of and really demonstrates a broader push by OFCCP to hold federal contractors accountable for pay inequities. And as part of that settlement, OFCCP claimed that Pfizer discriminated against 86 females in their professional positions. And the OFCCP determined that they had paid those professional females in those professional positions less than men in similar positions. So that's a significant back pay liability that Pfizer has taken on. But in addition to that, and what's typical we see in these conciliation agreements is that the company, Pfizer, is also being asked, required to set aside separate financial accounts in the amount of $500,000 to reserve for future salary adjustments. Also required to provide extensive training. They're also required under the conciliation agreement to conduct further compensation analysis of their workforce. So there's a lot going on there, and we can see the trend in what is happening with these audits. Next slide, Kathy. So we also want to bring to your attention two significant developments that OFCCP has taken this year with regard to their internal rules and their scheduling letter. So with regard to the internal rules, the OFCCP has recently issued what they refer to as a pre-enforcement notice and conciliation process. Those rules, as revised, has granted OFCC broader discretion and leverage. The rules passed by OFCCP in this regard has eliminated evidentiary requirements for OFCCP to issue what they refer to as a predetermination notice or a NOV, a notice of violation. It reduces time for employers to respond to predetermination notices. It will also remove any reference to theories of discrimination. So in essence, what the OFCCP has done is given itself a significant amount of leeway and leverage to find federal contractors liable for discrimination in connection with an audit. So one of the other issues that OFCCP has, or moves that they've taken, is to revise their scheduling letter. The OFCCP's scheduling letter, which is used to inform federal contractors that they have been scheduled for an audit. And when a federal contractor receives the scheduling letter, it lays out an extensive list of itemized data that the federal contractor is required to produce to the OFCCP at the outset of the audit. And one of the significant changes with the scheduling letter going forward is an overhaul of the compensation components that will be required to be produced by federal contractors. And federal contractors will now have to produce 2 years of compensation data. Previously, it has only been 1 year of a snapshot data. They will be required to provide much more extensive data on the factors that impact pay within your organization, a detailed documentation about your organization's compensation analysis and your structure, much more information about the scope of your compensation data. And this will all be produced at the initial outset. It is all initial data and document request. And those document requests will continue throughout an audit. But what the OFCCP has done is required employers, federal contractors produce a significant amount of data, particularly on the compensation piece at the outset of an audit. All of these pieces, particularly when put together, lessens the evidentiary obligations of OFCCP to demonstrate discrimination in connection with an audit in a concise or clear way that federal contractors can respond to and to counter. And it will also give OFCCP more discretion to find discrimination and grant the agency leverage in negotiating what ultimately might be a settlement in a form of a conciliation agreement. OSCCP has announced that it will use this revised scheduling letter through at least August 31, 2026. And we are yet to see what will come of these developments, but we certainly know that one of the trends that we're seeing is a focus on pay equity, and employers should therefore be thoughtful and mindful about looking at your affirmative action plans, looking at your compensation structure, and discussing sort of internally about any potential pay disparities within your compensation structure. That's it for now, Kristen.
Great. Thank you, Krista, for your time and lots of information. There's a lot going on in that area. Next up is our associate here in Syracuse, Janelle Doobie, to talk about a new statute of limitations in the world of employment discrimination claims. Thanks, Janelle.
Thanks, Kristen. Good afternoon, everyone, and I'm so happy to be with you all today to talk a little bit about an important change in the law that's going to affect New York employers specifically. So recently on November 17th, Governor Kathy Hochul signed a bill which amends the New York State executive law by extending the statute of limitations for filing administrative complaints of unlawful discrimination with the New York State Division of Human Rights. The extension of the statute of limitations is from 1 year to now 3 years. So prior to this change, the statute of limitations for filing claims involving sexual harassment only with the Division of Human Rights was 3 years, and the statute of limitations for filing all other claims of unlawful discrimination was 1 year from the date of the alleged discriminatory practice. So now, based on this change in the law and in an effort to achieve consistency across all claims, all complaints of unlawful discrimination, whether they involve sexual harassment or not, must be filed with the Division of Human Rights within 3 years of the alleged discriminatory practice. This new law with the 3-year statute of limitations is going to be effective beginning on February 15th, 2024, and it's going to apply to all claims that arise on or after the effective date. So claims of unlawful discrimination that relate to events that occurred prior to the effective date of February 15th will still be subject to that 1-year statute of limitations. Whereas anything that occurs after the effective date is going to be subject to this new 3-year statute of limitations. And we can likely anticipate that the state is going to have some difficulty and some confusion surrounding which claims are going to be subject to which statute of limitations. So I'm sure we're going to have some issues kind of parsing out which statute of limitations is going to apply. So this change is pretty significant just because the state has initiated several efforts to make this happen since 2018. There's been different bills, they've been introduced in different legislative sessions and renamed and so forth and so on without any success. So this is a longstanding effort by the state to extend this statute of limitations to give individuals and employees some more time to file administrative complaints with the Division of Human Rights. So this extension from 1 year to 3 years is just another example of the state's efforts to strengthen employee rights and protections under New York law. We've seen significant efforts, particularly in the past couple of years, where New York State is trying to make laws more employee friendly. And as a result, we'll likely see an increase in complaints that are filed with the Division of Human Rights, specifically with respect to unlawful discrimination in the workplace. So again, this new law only applies to administrative complaints filed with the state agency, the Division of Human Rights. But similarly, the statute of limitations for filing claims of employment discrimination in New York State court is also 3 years. So now we've got consistency across all claims filed administratively and then also in state court. And then as a reminder, New York individuals and employees have the option to file a complaint directly with the Division of Human Rights, or they can also file a complaint in New York State court. Both are going to be 3 years again. However, we thought it was worth mentioning that under federal law, there's some different limitations that we need to keep in mind. So first, employees have a 300-day statute of limitations from the day of the alleged unlawful discrimination in violation of federal laws, so Title VII, ADA, ADEA laws to that effect, to file an administrative complaint with the U.S. Equal Employment Opportunity Commission. And unlike in New York state law, under federal law, employees have to go through the EEOC's administrative process, meaning they have to file a complaint with the EEOC and go through that process before they can go to federal court. Under New York law, you can do one or the other. And then we also thought this would be a good opportunity to remind everyone of the administrative process for filing complaints and going through the Division of Human Rights investigative process. Comes up in my practice a lot and here in Syracuse and all throughout Bond. So we thought it was a good time to remind people of the steps that are involved in the process. So as I've already mentioned, the first step of the process is filing a complaint with the applicable regional office. Complaints can be filed via mail, email. Individuals can also just call the DHR directly and they can fill out the form for them. So then once a complaint is filed, an investigator will be assigned who will then investigate the facts of the complaint. And then the entity alleged to have engaged in the unlawful discrimination, so the entity that the complaint is against, known as the respondent, will be provided with notice of the complaint from the Division of Human Rights, and then they'll be given an opportunity to respond through use of a position statement, which generally will just explain the facts and lay out the respondent's legal position when it comes to the allegations against it. So once we have the complaint and then the respondent's position statement, then the investigator will have the opportunity to further investigate the allegations in the complaint, and they can do this through various different means and methods, such as written correspondence to the parties, telephone conversations, site visits, fact-finding conferences, requests for information, or any combination of these methods. So once the investigator completes their investigation, they're going to issue a determination. And that determination will either be a finding that probable cause exists to believe that the respondent engaged in unlawful discrimination, or that no probable cause exists to believe that the respondent engaged in unlawful discrimination. If there is a no probable cause determination, the complaint will be dismissed and the case will be closed. However, just to keep in mind, individuals, upon receipt of a no probable cause determination, individuals do have 60 days from the date they receive that determination to appeal it in New York State Court. And then if there is a probable cause determination, then the case will proceed to a public administrative hearing in front of an administrative law judge. During that hearing, both sides will have the opportunity to present evidence and support their positions. After that hearing, and based on the evidence presented at the hearing, the administrative law judge will issue a recommended order advising the parties and the commissioner for the Division of Human Rights how they believe that the case should be resolved, meaning either in favor of the complainant or in favor of the respondent. The commissioner for the Division of Human Rights will then review the allegations, the evidence, and the administrative law judge's recommended order, and they will issue a final commissioner's order. So we encourage all employees to be sure to consult with legal counsel to prevent and address any claims of unlawful discrimination that arise in their workplace, and then be sure to reach out to us for any assistance in resolving those claims.
Thank you, Janelle. It'll be interesting, moving forward, trying to defend claims that are now 3 years old instead of 1 year. It gets very difficult, with employee turnover. Are your witnesses available? What information do you remember? I mean, it definitely will change the game on some of these cases. So significant development in New York state law. Thanks for sharing that with us. Finally, last but certainly not least, we have Subha Viswanathan, who will talk about the new numbers under New York state law for 2024. So tell me, what is my teenager going to get a raise to as of January 1st, Subha? Who makes minimum wage?
Thanks, Kristen. Yeah, we have some clarity now from the New York State Department of Labor regarding the exempt salary levels, as well as various tip credits that are applicable in the hospitality industry. So I'm going to get into all that. But first, let's talk about the minimum wage. Next slide, please, Kathy. So these were already established by legislation. This is not a recent development, but it's a helpful reminder to everybody that the minimum wage is going to go up both in upstate New York as well as downstate, effective January 1st, 2024. It's going to go to $15 per hour in upstate and $16 per hour downstate. The legislature did also establish minimum wage increases for the following 2 years, 2025 and 2026. It's going to go up 50 cents each year, both upstate and downstate. Next slide, please, Kathy. Before I get into the exempt salary levels, let's talk about the tip credits that are available for employers in the hospitality industry. And these are proposed regulations from the New York State Department of Labor. We anticipate that they will be adopted, but keep in mind that at this point they are just proposed regulations. For food service workers, which essentially includes anybody in a restaurant who directly is involved in food service other than fast food workers, the tip credit is going to go up to $5.35 per hour in downstate, which means that the actual cash minimum wage that food service workers must receive downstate is $10.65 per hour. And in upstate, the tip credit is going to go up to $5 per hour, which means that the cash wage in upstate for tipped food service workers has to be at least $10 per hour. It is a good idea for restaurant employers to keep a record of have people self-report their tips so that you'd be able to prove, if you're ever audited by the Department of Labor, that employees were earning in hourly tips at least the amount that you're taking in the tip credit. There are also proposed increases to the tip credits for food service workers in 2025 and 2026. I'm not going to get into those right now, but I will certainly in December 2024 do a little reminder of what those tip credits are going to be for the following year. Next slide, please, Kathy. For service employees, and these are employees who customarily receive tips and meet the tip threshold, other than food service workers or employees in fast food establishments, there's a lower tip credit for these employees. It's $2.65 per hour downstate, which means that the cash wage for service employees in the hospitality industry has to be at least $13.35 per hour. And the tip credit for service employees upstate is $2.50 per hour, which means that the cash minimum wage has to be at least $12.50. And again, those tip credits are going to go up in 2025 and 2026. Next slide, please, Kathy. So here are the tip thresholds. And what this means is that this is the weekly average of tips that service employees in resort hotels and service employees in restaurants and non-resort hotels have to earn in order for a hospitality industry employer to be able to take advantage of the tip credit for service employees. So at resort hotels, service employees have to earn on average at least $8.95 per hour in tips downstate and at least $8.40 per hour upstate. In restaurants and non-resort hotels, service employees have to earn at least $3.45 per hour downstate on average, and at least $3.20 per hour upstate on average. And again, these will be increased in 2025 and 2026. Next slide, please, Kathy. All right, so this is the information that most of you have probably been waiting for. And I've been getting a lot of questions about it. I think we all have. And until very recently, our answers were based more on kind of guesswork and speculation about what the Department of Labor would increase the exempt thresholds to. But now we have proposed increases, which in upstate for the executive and administrative exemption will be $1,124.20 per week, effective January 1st, 2024. We had been guessing that the amount would go up to $1,125, principally because the historic trend has always been that the minimum weekly salary to qualify for the executive and administrative exemptions has always been 75 times the minimum wage. And since the minimum wage in upstate is going up to $15 per hour, we all kind of assumed that it would be $1,125, which is 75 times that amount. But for some reason that I don't fully understand, it's actually 80 cents less than that. The minimum salary levels are going to go up in upstate to $1,161.65 effective January 1st, 2025, and then to $1,199.10 effective in 2026. And downstate, so downstate, if you do the math, they actually did follow the trend of 75 times the minimum wage, but they didn't upstate for some reason. So those are the minimum salary levels for the executive and administrative exemptions downstate: $1,200 effective in 2024, $1,237.50 in 2025, and $1,275 in 2026. Keep in mind that all of these salary levels are inclusive of board, lodging, or other allowances and facilities. So if you are an employer that provides, for example, meals or boarding or some sort of housing for your employees, the value of those meals and the lodging can be counted towards the minimum salary levels for the executive and administrative exemptions. There are limits to how much you can count, but they can be counted. Next slide, please, Kathy. There is still no New York salary threshold for the professional exemption, but keep in mind that the federal salary level for executive, administrative, and professional exemptions is currently $684 per week, exclusive of board, lodging, or other facilities. So under federal law, for that amount, you cannot count board, lodging, or any other allowances. There is a proposed rule that's been issued that I'm sure you're all aware of by the US Department of Labor that will increase the federal threshold for the white collar exemptions to $1,059 per week. That is still in the consideration stage. I believe the comment period has already expired, but I'm guessing that the US Department of Labor is busy at work reviewing the comments and finalizing the rule. So I'm guessing we'll see something, we'll probably see a finalized rule sometime in 2024. And again, that could be subject to some litigation, just as it was the last time the US Department of Labor tried to raise the minimum salary. There is no federal salary level requirement for certain types of professionals. Teachers, doctors, medical interns, and residents and lawyers are not subject to any federal salary level requirements to meet the professional exemption. And as we know, there's no state law exemption either for those employees. Next slide, please, Kathy. This particular piece of legislation caused a lot of confusion for employers in New York State because it created some impression that the salary level to qualify for the exemptions was increasing to $1,300 per week. That's not what this particular legislation did. What this legislation applies to is certain types of exemptions from state labor law requirements under Article 6 of the labor law. So effective March 13th, 2024, In order to be exempt from certain state laws, bona fide executive, administrative, and professional employees will need to earn at least $1,300 per week. And what are those particular state laws? So under Section 190 of the labor law and 191 of the labor law, there's a definition in 190 of clerical and other worker that excludes individuals who are bona fide executives, administratives, and professionals who earn more than $1,300 per week. And under Section 191 of the labor law, those particular employees who meet the definition for clerical and other worker have to be paid at least semi-monthly, so twice a month. So what this exemption does is it essentially eliminates the pay frequency requirement for exempt employees who earn at least $1,300 per week. Similarly, in Section 192 of the labor law, in order to get paid by direct deposit, most employees have to give written consent to that. But bona fide executive, administrative, and professional employees who earn at least $1,300 per week, you do not need written consent to pay them by direct deposit. Labor law section 198C is a law that imposes criminal penalties for failure to pay certain types of benefits or wage supplements, like vacation pay upon termination, accrued vacation pay, for instance. And again, for that law does not apply to bona fide executives, administratives, and professionals who earn at least $1,300 per week. And that's it for me, Kristen.
Okay, thanks, Suba. I know we've gone a little late here today, everyone, and thanks, for sticking with us. There are a few questions, Suba, if you could take a look, but one that we got a few times in the Q&A is, those salary levels are proposed. When will we hear that they're actual? I imagine we'll get some sort of news sometime this month.
Yes, hopefully. I think that comment period also just ended, so I think it'll be hopefully before Christmas we'll hear something, but if not, it'll be before the end of the year.
And I guess the real answer is on this webinar. We will let you know. We'll keep an eye on it. So thank you, Suba. Thank you, everyone, for being here. Here's the contact information for today's presenters if you have any questions, and see you next week.